All right, let's jump right in. Have you ever been staring at an exam question where a contract seems to say one thing, but then a lawsuit comes along trying to do the complete opposite? Well, that's exactly what we're tackling today. We're going to deconstruct a classic professional liability question, but we're not just here to find the answer. Nope. We're going to uncover the legal strategy behind it. By the time we're done, you'll see how to spot these tricky scenarios and handle them like a pro. Let's get to it.
Okay, so here's the full picture. We've got a professional engineer with a contract, and that contract very clearly limits their liability and says, hey, no consequential damages. Then a design error happens. It doesn't cause any physical damage, but it does cause the client to lose money from business interruption, lost profits. So what does the client do? They sue for negligence. The million-dollar question is, when a court looks at this mess, what's the single most important factor they're going to consider to decide if that liability clause is actually valid? To solve this puzzle, we've got a really clear 6-step roadmap. First, we're going to pull out the key facts. Then we'll define the legal concepts you absolutely have to know. After that, we'll dive into the owner's strategy. Why sue for negligence anyway? Then comes the main event. We'll go through the options one by one. And to wrap it all up, I'll give you a simple takeaway method you can use on any similar question, plus a quick review of the key terms. Let's begin.
All right, part one, the question on liability. Let's set the scene. Okay, let's break this down into bite-sized pieces. We have a contract, and inside it, a liability clause. That's piece number one. Then a mistake happens, and this is important, it only causes economic loss, just lost profits. And here it is, the most crucial detail of all. The lawsuit isn't for breach of contract. It's for negligence, which is a tort. You gotta keep that distinction in mind because, trust me, it's the key to this whole thing.
Next up, part two. Let's unpack the core concepts, the legal foundation we're building on.
First off, what in the world is a limitation of liability clause? You see these all the time in professional services. The easiest way to think of it is as a financial safety net. It's basically where both sides agree right up front, look, if something goes wrong, here's the absolute maximum amount of money one of us will be responsible for. It's all about managing risk before a project even kicks off. Next up, consequential damages. Now, these aren't the direct costs, like the money it takes to fix the design error itself. No, these are the secondary knock-on effects. It's the business interruption losses our question is talking about. The client lost profits because the engineer's design was flawed. That contract clause was specifically trying to prevent claims for these kinds of damages. And this right here, this is the heart of the conflict. You've got two different worlds of law colliding. Contract law is all about the promises you made inside the agreement, but tort law, and in our case, negligence, is about a bigger duty. It's your professional duty to society not to cause harm, and that duty exists outside of any specific contract. The owner's strategy is pretty slick. They're trying to use tort law as a backdoor to get around the limits they agreed to in the contract. So let's move on to part three, analyzing the scenario and really look at this strategic lawsuit. Think about it for a second. The engineer made a designer, so they clearly breached the contract. Why not just sue for that? What's the clever reason for bringing a negligence claim instead? It's a strategic end run, plain and simple. The owner's lawyer is making a very specific argument. They're saying the engineer's mistake wasn't just a simple contractual boo-boo, but a breach of their fundamental professional duty of care, a tort. And their big hope is that the court will agree that this duty is separate from the contract. And because of that, it's not covered by the contract's liability limits. See how clever that is? All right, time for the main event, part four, evaluating the options. Let's use the process of elimination. So let's start by looking at option A. It suggests the real key is whether the clause was negotiated between parties of equal bargaining power and doesn't offend public policy. This one gets right to the very core of how the contract was created in the first place. Let's dig in and see why this is the exact lens a court would use. So this option is all about the fairness of how the contract was made. As you can see, courts basically ask two big questions. First, was this a fair negotiation between two equal parties? Or was it a take-it-or-leave-it kind of deal where one side had all the power? And second, does this clause violate any fundamental laws or principles of public safety? If that contract was made fairly and it doesn't put the public at risk, a court will almost always enforce it, yes, even against a negligence claim. This is the bedrock test. Now let's look at a very, very tempting wrong answer, option B. This one suggests that negligence claims are just off limits, that you can't use these clauses for negligence at all. This is a classic trap.
This is such a critical point for any professional to get. You can absolutely 100% limit your liability for negligence in a contract. There's no blanket rule that says you can't. The key, just like we saw in option A, is that the clause has to be well-written, super clear, and most importantly, it has to be the result of a fair negotiation. So option B is just wrong because it states an absolute rule that doesn't exist in law.
Okay, let's move to option C, another distractor. This one's tricky because it uses a real legal concept, foreseeability, but it applies it to the wrong part of the problem. Here's the key distinction, and it's a little subtle. Foreseeability is a tool the court uses after it's already decided someone is liable. It helps figure out the scope of the damages. The court asks, what harm should you have reasonably predicted your mistake would cause? But our question is about a step before that. We're asking, is this contract clause that limits liability even valid in the first place? Foreseeability just isn't the right tool for that job. Okay, part 5, the final answer debrief. Let's boil this all down into your personal takeaway strategy. Here it is, a dead simple 3-step method. First, always identify the type of lawsuit. Is it based on the contract or is it a tort claim like negligence? Step 2, look at the clause itself. Is it written clearly? And finally, step 3, apply that ultimate test from option A. Was the negotiation fair and does the clause respect public policy? This framework will get you to the right answer every single time. And finally, part 6, a quick key terminology review. Let's make sure you've got the professional's glossary locked in. So here are our heavy hitters. Limitation of liability, that's the clause that caps the damages. Consequential damages, those indirect losses, like lost profits. Negligence, a breach of your professional duty of care. Bargaining power, which is all about whether each side could negotiate freely. And public policy, those fundamental legal principles that no contract is allowed to violate. Knowing these cold is absolutely crucial. And I'll leave you with this final thought to chew on. We know a fairly negotiated clause is really strong. But what if that clause, even if it was agreed upon by 2 huge, powerful companies, directly puts public safety at risk? Imagine a clause that allows a bridge to be built with shoddy materials. That scenario gets right to the heart of public policy. The idea that no private deal, no matter how well negotiated, is ever allowed to harm the public good. It is the ultimate trump card in contract law. Something to think about.